Now, there's a number of matters that I want to just touch base about quickly, Mr. Cooksall, and let me tell you what I am thinking at this stage. I will have to have a bit of a discussion about a recusal application. Then I want to discuss with you the issue of the subpoenas. In terms of your proposed summons to add parties, amend the originating motion and put protected costs order, what I am inclined to do is to make an order directing you to file material on which you wish to rely in support of those applications and to deal with that on the papers at a later date. But that seems the only thing I can do about that at the moment.
Your Honor, we would want to be heard in court. We emphasize that there is authority about.
All right, well, we will come back to that in a second then. Let's deal with the recusal application. I take it that, from the affidavit of Mr. Ansell, are you making a recusal application at the moment or this morning?
Yes, Your Honor.
All right. Is there anything new beyond that which has been raised or is capable of being raised at previous recusal applications?
Yes, Your Honor.
What's that?
So, well, the latest thing, Your Honor, is that Your Honor's communicationer, when Your Honor's chambers advised us of the hearing, basically indicates, as is stated in Mr. Ansell's affidavit, that the court has considered that the subpoenas may not be granted.
Well, can I interrupt you to say that what I am provisionally thinking in this proceeding, 4028, is to grant you leave to file the subpoena addressed to the Victorian Legal Services Commissioner without prejudice to that party's rights to make application should they wish to have it set aside. But to deny you leave to file the subpoena addressed to the Chief Commissioner of Police.
Yes, Your Honor, we had anticipated that based on Your Honor's.
You had anticipated that I was going to give you leave to file the subpoena addressed to the Legal Services Commission?
No, we had anticipated that Your Honor would not give us leave to file the subpoena against the Chief Commissioner. In circumstances where the court has prevented me from having an injunction application listed because I wanted that subpoena to be issued, and essentially Ms. Anaz is the reason why the firm was shut down, we have affirmed an affidavit to that extent. We have discovered extensive evidence in the only proceeding about how VLSB has used Ms. Anaz. This morning I was advised by IBAC that they are investigating Victoria Police in Connect. This is a criminal investigation.
Are you talking? What are we on at the moment? The recusal application?
This is about Ms. Anaz, conspiracy where we put.
Okay, Mr. Cooksall, I interrupted you. I appreciate that. We are just dealing with the recusal application.
Yes.
No, Mr. Cooksall, I interrupted you because you had assumed the decision I was going to make in light of the subpoenas. I just gave you what my provisional thinking on that was so you could factor that into your recusal application, that was all.
Yes, Your Honor, and also,
I want to bring you back to the recusal application to identify what has changed since the last time you brought the recusal application.
Well, Your Honor, if Your Honor refers to paragraph.
Mr. Ansell's affidavit?
Opening the affidavit of Mr. Ansell. And I refer to paragraph. Okay, so this is the paragraph concerning the hearing on.
Just give me the paragraph number.
The 19th of February.
Can you give me the paragraph number, Mr. Cooksall?
I'm just looking for it, Your Honor. Okay, found it. So this is paragraphs 9 to 13. Paragraphs 9 to 13.
All right, so you say that. All right, I have looked at that.
So on the 19th of February the exchange between Your Honor and myself was that the court would issue the subpoenas and only schedule a mention if the court was unwilling to issue the subpoenas as an abuse of the court process. When the court informed us that it was not, that it was scheduling a mention, we concluded from that, based on what His Honor had firmly indicated as we have identified in the transcript, that His Honor had declined to issue the subpoena against Ms. Anaz. Now, Your Honor, let me clarify the basis of the recusal application. Our first basis is apprehended bias. If the court rejects that, we will allege actual bias and I will state the grounds for that. But I rely on multiple authorities, including essentially, I am just bringing up the.
Look, I don't think you need to address me on the law about the matter, we have done that.
This is a very technical point, Your Honor, and we have done a lot of research, so I appreciate if we could be heard. Essentially, the law states that an actual bias application should not normally be raised and should only be raised in very specific circumstances.
Mr. Cooksall, you don't have to tell me that. Just tell me what the specifics are. Just tell me why you think what the basis of the actual bias allegation is, your submissions.
Okay, so Your Honor, that we say is that a conflict of interest has arisen because what Your Honor has done actually gives us grounds for claims in tort law against Your Honor, of which, and of the plaintiffs I am decided that I will pursue such action. I am willing to give undertaking in court at the moment.
What would the cause of action be?
So Your Honor, judges of superior courts have community.
No, just give me, what is the cause of action?
We say that the court has maliciously in the sense of either recklessly indifference to the harm that it would cause to us, or.
Yes.
But we don't have to actually distinguish. Maliciously committed jurisdictional errors in respect of which judicial immunity does not apply.
Okay.
In particular I will rely on Your Honor's administrative decision of the 23rd of November that was clearly in excess of jurisdiction.
Which one was that?
That was when I had foreshadowed an application for injunction and Your Honor had preemptively made a decision barring me from making an injunction application administratively.
All right, these are matters that have been discussed in the past in recusal applications.
Yes, but Your Honor.
I am really focused on what's new.
Yes, but Your Honor, in circumstance, so the malice is an important element and it is a difficult element to prove and it should not be alleged irresponsibly. We say that the preponements of the matters including the latest event of Your Honor refusing to issue subpoena against Ems Anaz clarifies that the decisions that Your Honor has made in respect of the Anaz review proceeding have been made improperly for the purpose of preventing the enforcement of the law.
All right.
Because the court, Your Honor, is doing the same thing in the other proceedings, in our submission it is clear that Your Honor is seeking to shield Ems Anaz. We don't have to speculate about the reasons as to why, but we note that Your Honor has been exposed to a number of documents that Ems Anaz has improperly provided to Your Honor. There is authority about the prejudicial impact of those documents and the subconscious bias that cannot be reliably averted, but if Your Honor does not accept the apprehended bias application it would leave everybody, by that I mean the parties, and I'm sure the court itself, in a very difficult predicament because it would require that the court assess the reasonableness of those claims after conducting a full-on hearing of evidentiary material and submissions on law, and that course is generally said to be undesirable by the authorities. We consider that the current matter is a matter of great public interest and I am speaking for myself in particular, I think I have a duty to hold the LSB and everybody who has conspired with them to.
That's a different point, Mr. Cooksall.
No, I think I have a duty.
I think we need to go back to the recusal application.
Well, Your Honor, I think that Your Honor is an impediment to my ability to hold different people who have committed criminal conduct.
All right.
For which, by the way, the IBAC is currently, they have voluntarily opened an assessment of whether or not criminal investigations should be commenced against the LSB. After Justice Ginane came out with a decision that they had an obligation to consider relevant facts about the Victoria Police application. They have improperly sought to confidentially communicate to me that they were inclined to investigate the LSB in a manner meant to achieve the settlement of my misfeasance claim against the IBAC. I am not investigating them in the first place, that is my position. I wish to produce documents about what they say is without privileged communications and settle the claims, but they have clearly indicated that what the LSB did was shocking and outrageous.
All right.
In private mediation, because they knew that I would raise these matters in public, and we note that Your Honor has not, despite Your Honor's condemnation what Your Honor considered to be improper conduct on my part, made any serious comments in relation to the LSB's conduct, and in fact, Your Honor has, in our opinion, taken steps which the LSB has exploited to take detrimental action against me. When the LSB came to know about the IBAC considering them in relation to our previous complaint, the investigation of our previous complaint, the very next day or 2 or 3 days later, after the matter was filed in court by an IBAC officer by way of affidavit in a proceeding in which the LSB was a party. The LSB immediately after that sent letters to Mr. Ansell, me and Ms. Zhu threatening to commence bankruptcy proceedings on the basis of the lump sum orders that Your Honor has made. And basically, it's a threat to stop litigation against it. That's what they did against Ms. Di Gregorio, which again, in our submission, Your Honor, improperly, albeit we are not saying that it was Your Honor's intention to, but we think that what Your Honor has done in this proceeding has helped the LSB in intimidating parties and also has given them the encouragement to continue doing that sort of thing. After Your Honor came back with a decision that we were wrong to judicially review the judicial registrar, its orders, the LSB colluded with a small publication agency to publish the fact that I have been unsuccessful in, it was extremely inflammatory, the wording that was used in the article. But, and also, quite scandalous, it said something to the effect that I failed to bring the LSB to its knees or something to that effect. And Your Honor's decision was supported. It's a publication that the LSB has previously used against us, and in circumstances where Your Honor has not identified the particular statutes that I have identified Judicial Registrar did breach. Your Honor has not identified how Judicial Registrar Keith did not breach the particular statute that I have alleged he breached. We, in combination with everything else, have grounds to now properly allege that Your Honor has, at the very least, been recklessly indifferent to what is going on before Your Honor to the serious matters of which there is evidence. And, I speak for myself, Your Honor, I cannot imagine that we would not meet the threshold that one reasonable person would agree with us. In fact, IBAC agrees with us that the LSB's allegations should be considered in relation to whether or not criminal charges should be brought against different people employed by the LSB. So in those circumstances where Your Honor, and I also note that the modern litigant obligations which Your Honor has repeatedly refused to enforce have another statutory basis in S38 of the Charter of Human Rights and Responsibilities. And, Your Honor, the other new development that has taken place is that Your Honor's decisions have been quoted by every government agent that has had an axe to grind against me. Without fail, anybody who has sought to allege improper things against me as exclusively relies on Your Honor's orders, and it is clear why they have done. In fact, the magistrate who is currently alleging that I have committed contempt has relied on Your Honor's decisions because, when I pointed out the number of errors that he has committed in the matters, he basically pointed out Your Honor's ruling about how multiple errors are not indicative of an inability to judge matters according to the law. They basically mean nothing.
All right.
Now I am not saying that Your Honor could have reasonably anticipated that that is how the decisions would be abused, but I think it is extremely irresponsible given Your Honor's knowledge of all the matters that I was involved in, and I have recently complained about the fact that Your Honor's orders were being abused, and then Your Honor continued to basically improperly maintain the effectiveness of previous orders in which allegations have been made. Your Honor, it has been, now, when I foreshadow misfeasance proceedings against members of the prosecution, I am compared to a person who stalks people and therefore their names should be suppressed from the court record, and that application has been granted by magistrates relying on Your Honor's orders or reasons that I am an obsessive person who could potentially engage in criminal conduct in stalking people and so on and so forth. And Your Honor, the other part is, I did not even extract the documents from her phone. Your Honor had evidence before himself that it was Ms. Di Gregorio who had done that.
All right, Mr. Cooksall, you have had, I think, a fair opportunity to present the argument.
No, but this is a recent thing. I have recently suffered prejudice as late as May 2024.
Mr. Cooksall, I think I dismiss your application that I recuse myself. I am not persuaded that a fair-minded lay observer would think that I might not bring an open mind to the issues that arise. The arguments in support of the application really reduce to a contention that I have made a series of errors in the decisions and also that the decisions I have made have had detrimental consequences to you.
And you have prejudged the matters, Your Honor, you have prejudged the matters, not releasing subpoenas.
If I have made errors, they can be the subject of an appeal, but an error does not give rise to an apprehension of bias. Similarly, if the decisions I have made have had detrimental consequences for Mr. Cooksall, that is really a reality of litigation, and that cannot be a reason for which a reasonable, fair-minded, lay observer might think I would not bring an open mind to the issues that arise.
Your Honor, there is another issue.
That's, Mr. Cooksall, the fact that it's anticipated that proceedings might be brought against me personally on the basis that I have, including allegations that I have engaged in conduct which is recklessly indifferent to Mr. Cooksall's rights in a way that sits outside the judicial immunity, cannot be a reason for me simply to recuse myself, because it cannot be the case that threatened proceedings of themselves can be a reason for which the judge has to recuse themselves. So I am not going to recuse.
Your Honor, we are not being given an opportunity to be heard properly. We wish to.
Mr. Cooksall,
we didn't get an opportunity to develop the argument.
You've had half an hour, Mr. Cooksall.
Well, Your Honor, that's an arbitrary time.
Can't do that to none.
We wish to find authority and development the argument about why the conflict of interest is an automatic disqualifications round.
Mr. Cooksall, you have not identified, you have had half an hour or thereabout, you have not identified a conflict of interest.
I have, Your Honor. So once.
What is my interest that is in conflict with yours?
Your Honor, in our view, has a misapprehension of the law about how conflict of interest arises, the fact that indistinct 12 hours 7 minutes and 14 seconds claim exists as the conflict of interest. It doesn't actually, the conflict doesn't arise after the commencement of the proceeding, it's the fact of the existence of the claim and what Your Honor meets.
Mr. Cooksall, I am against you on that. I do not believe that the fact that a litigant informs the court that they will or are considering or may have a cause of action against a judicial officer means that there is a conflict of interest of a type that means the judicial officer must recuse themselves.
May I cite authority?
No, I'm going to push on. I'm telling you, that's on the transcript. That's my view. In my view, the fact that you have said you are thinking of bringing proceedings against me mean I have to recuse myself.
No, I'm just, Your Honor, I am giving an understating to the court that I will commence proceedings against Your Honor.
All right, well, if you have got proceedings to bring, you can bring your proceeding. But Mr. Cooksall.
No, but what I am saying, Your Honor, is that the conflict of, and also, I don't understand why we can't cite authority in this respect. It's highly unconventional.
Mr. Cooksall, I am trying to get this proceeding underway. If there is, you have produced an affidavit, an unsworn affidavit at the time that mentioned it was listed to start.
Is Your Honor not accepting the I'm detecting?
If you can put in on an application. I am making a ruling now, dismissing your application that I recuse myself. So let's move on.
And why would we not be able to cite an authority, Your Honor?
Mr. Cooksall, I have made my decision, we are moving on. So the next point is, in terms of the subpoenas, I have to say that, let me see, that I will give you leave to file the subpoena addressed to the Victorian Legal Services Commissioner, substantially in the form of the draft provided dated the 29th of February 2024. But I am going to make it clear in the order that that is without prejudice to any rights that Victorian Legal Services Commissioner might have to apply to have that set aside.
Well, Your Honor, that goes without saying.
That goes without saying. And tell me how you say that the subpoena addressed to the Chief Commissioner of Police has a forensic purpose in this proceeding, which is focusing on the conduct of the Victorian Legal Services Board in the appointment of the other defendants to People Shop Pty Limited.
First of all, Your Honor, in asking that question, Your Honor is taking the role of an advocate.
All right, let me say that, I know you present an argument that the court, it's not my role to look at whether there's let me start again. You take the view that it's not my role on this subpoena application to consider whether
the evidence is relevant,
to deduce a process or anything like that. I just simply have to issue the subpoena and leave it.
No, that's.
I'm against you on that, Mr. Cooksall.
No, that's not my position anyway.
I take the view that if I form the view that it's clear that a subpoena is an abusive process, then I'm not going to give leave to have it issued.
But Your Honor,
on that point that I'm asking you, how it is you say that this subpoena, it's on the cards that this subpoena will produce material that is relevant to the issues that arise in this proceeding.
Your Honor, firstly, all we have to establish is a pattern of relevance. We have to go no further. If there is any possible connection that is not merely speculative, then those documents are, because of the very confined nature of their scope, we have a right to have them.
You say, the confined nature. It's a very broad subpoena, is it not?
No, when I say confined, Your Honor, what I mean is it's a finite volume of documents. It's not openly described, it's not weighed, a person can identify what the documents are. That's the definition. I had sent the court a document that summarized the parties in this respect, and I can refer the court. That's also exhibited to Mr. Ansell, David.
Tell me what issue that arises in this proceeding. The police document to your effect.
Okay, so Your Honor, first of all, the raid that was conducted at the firm's offices on the 22nd of August. It was conducted through the Court Precinct of Victoria Police. One of the officers,
Mark Homburg.
Mark Homburg, that's right. Mr. Mark Homburg has created LDR record of the purported criminal investigation that he has commenced pursuant to the LSB's instructions to him about how I was abusing the firm to commit financial fraud of some sort. Now, the only reason why we're aware of that is because Mr. Homburg sent an email to Mr. Oni advising him that Mr. Howard Bowles of the LSB now has all of my documents. Personal documents he has filed. He also has of Ms. Zhu's documents and Ms. Di Gregorio's documents, and if Mr. Oni wants any of these documents, he can just contact Mr. Howard Bowles directly. And then he referred Mr. Oni to a field entry note in their matter management software. And that is one of the documents that we are seeking through the subpoena. It's identified expressly.
Which document is that? Which paragraph?
Yes, I'm just bringing up the exhibit. Just bear with me, Your Honor.
Sorry, it's Pennsylvania 30.
Yes.
But I'm looking at the subpoena.
Yes, Your Honor. So the subpoena are exhibited to the affidavit of Mr. Ansell.
I have the subpoena open in front of me.
But Your Honor, I just want to make sure we're referring to the same subpoena. The subpoena of today's date.
I've got a subpoena dated document the 29th of February 2024.
That wasn't in this proceeding, Your Honor. We provided the court with a copy of the subpoena.
Well, Mr. Cooksall, its proceeding number is SECI 2022-04028. And it's headed, Shivish Cooksall and others against Victorian Legal Services Board.
Okay, we provided the court with a version of that document.
So is this are you relying on a new form of subpoena?
It's not different in substance. One of the footnotes may be different. That is they're not new documents that are sought to the subpoena.
I've looked at a subpoena that you've previously provided.
Okay, I contend.
With this proceedings heading, is that the subpoena that you want have issue or not?
Your Honor, I don't have that in front of me at the moment, but I can bring it up to compare the two. But
you had changed. You have put together a new document.
No, we haven't changed anything materially. From what I understand, we have added some lines to the footnotes to clarify some matters. But the documents that are sought are the same in respect of the lease commissioner. But it's item 10, and I'll read the notes and documents associated with the police incident report.
Wait a moment, I haven't got it. I have to find this now.
It's on PG 122.
Of what?
Of PA 30.
PA 30.
Yep, 122 or 131.
So this is the, let me see, that's the.
Item 10.
What page? I've got 131 page exhibit.
Yep, 122 or 131.
122.
And I refer to paragraph 10.
Paragraph 10.
This is the field entry note that Mr. Mark Homburg referred to in relation to his note-taking of Mr. Howard Bowles' exploits at law firm's offices on the 22nd of August 2022. Again, Your Honor, we think that the court has failed adequate consideration to the content of subpoena and it's struggling because Item 9 literally seeks Victorian Legal Services Board's correspondence with the Commissioner. So, Your Honor.
Hang on, stop. Item 9 is all documents in relation to the Magistrates' Court proceeding, or of another Supreme Court proceeding, including those generated as a result of phone conversations, online conferences, in-person meetings, generated, shared, or received by the Victoria Police on account of their correspondence with a menu list of 16 different people.
Yes, and Your Honor knows that.
And you say that all of those things.
They're all associated, Your Honor, some Legal Services Board, then holding Redlick, this is the manager that they appointed to the firm. 9 Network Pty Limited. They came in with Mr. Howard Bowles. Mr. Sam Pucciara, again. Mr. Howard Bowles, Ms. Anna, indistinct. Ms. Anna, indistinct, sent emails to the magistrates in the intervention order proceeding. Your Honor, we have emails between Ms. Anaz and the police which indicate that how the LSB was communicating with the police.
All right, yes, but I think that's where you can prove that then, that the VLSB, but what's the point? The point is whether
we want to get all the information that there is. We have some, we want to get more. The court cannot stop us from getting more.
Mr. Cooksall, you keep saying that, and this an original.
I have authority, Your Honor, if you.
This is a proceeding by originating motion.
Your Honor, this is.
The issue is whether the board, suppose you're right, and Ms. Anaz did make a complaint and that caused the.
Your Honor, I take objection to Your Honor's calculation of matters. It's not a legitimate complaint, it's a conspiracy to fabricate facetious allegations of criminality against me and people who are supporting me in litigating those claims. What, Your Honor, this is getting offensive at this point. The manner in which Your Honor is concealing the truth, it's.
Yes, all right. Anything else, Mr. Cooksall?
Your Honor, we've suffered considerable detrimental effects because of the LSB's exploitation of Ms. Anaz. Your Honor has before him the letter that the LSB had sent to Mr. Ansell. It's exhibited to Ms. Di Gregorio's affidavit of the 20th to the 21st of December 2022. To which he was informed that his practice and certification would not be renewed.
Yes.
The main allegation in that is that Ms. Anaz has alleged that he had basically free reins to use his name and his signature. That's all that there is, Your Honor. Then Ms. Anaz has sworn an affidavit that it's because of her that the LSB took the action that it took. Your Honor, I would be hard-pressed to find a reasonable person who could think that Your Honor could bring an open mind to this matter. There is no justification for Your Honor denying the operation of the equitable jurisdiction of the court to me in respect of my things against Ms. Anaz. And there is no basis to conclude that when Your Honor is so committed to preventing us from enforcing the law in respect of her in one matter, Your Honor would not do the same thing in this matter. And the other matter, Your Honor, is that Your Honor is purposely or recklessly creating a distraction for us. In what, Your Honor, is exhausting our resources, limited as they are, in having to fight both the court and our oppressors when the court should have been coming our aid in these circumstances. It's against the public interest that Your Honor continued to sit in these matters. It catalyzes the affairs of the court. What Your Honor is doing is forcing us to make even more serious allegations which whether or we are being extremely restrained in expressing our grievances, which were foreseeable, and which we say were inflamed because of the court's failure to give us what is our right. And I think in those circumstances, given that we hold the position that we do, that this proceeding is not just about us, it's also about making sure that people that will be put through the same thing that we've been put through but will not have the tenacity and the resources supplied should not be prejudiced by the same people at least that have prejudiced us. In those circumstances, I think we have a duty to argue each matter robustly and not let the court through a misapprehension of the law or in fact impede the enforcement of the law against the statutory body that we say is perverting the course of justice. We have put into evidence why we could not raise the fuel up until now. By the way, Magistrate Williams found that the LSB had arguably colluded with Victoria Police. In that proceeding, he made judicial determination after giving the LSB an opportunity to address him and after the LSB failed to give any evidence about why His Honor should not hold that view. And, Your Honor, we have a document from Mr. Michael Howard, stating that Mr. Bowles has all the material in relation to our allegations of serious criminal conduct against Mr. Oni and his colleagues. and that Mr. Bowles needs to be contacted. And later on, Ms. Anaz facilitated the exchange of those documents between the LSB and Victoria Police. Mr. McAuliffe sought to mislead the court justice today in relation to that matter. Ms. Anaz had named Ms. Anna Elevezopoulos as the person to whom certain documents had to be communicated by Mr. Oni. Mr. McAuliffe said that it could be any Anna. Your Honor, the court has previously already stated pretty explicitly that it is uncomfortable with me as a layperson making allegations against lawyers. And the court has refused to consider the fact that Ms. Anaz exploited her relationship for commercial gain and essentially did what Your Honor's orders give reason to a lot of other people to suspect that I did.
All right, thank you, Mr. Cooksall.
Your Honor, this was a renewed application for refusal based on Your Honor's mischaracterization.
Mr. Cooksall, I'm not going to entertain any more applications for recusal by you today.
Your Honor, I don't think the court has jurisdiction to do that.
Can you mute, Mr. Cooksall, please? On the 7th of September 2023, the court ordered, among other things, that, subject to any order made by the trial judge to the contrary, paragraphs 1 to 3 of the plaintiff's summons, being a further amended summons filed the 3rd of November 2022, and the defendant's summons, being a summons filed on the 2nd of November 2022, are to be listed the hearing together. In paragraphs 1 to 3 of that summons, the plaintiffs seek determinations in relation to the conduct of the Victorian Legal Services Board in appointing the other defendants to certain positions that they held, in relation of the fourth defendant, People Shop Pty Limited, and determinations as to legal framework in which those appointments were valid or invalid. In February 2024, the plaintiffs indicated to the court that they sought to have issued subpoenas to produce documents prior to the hearing of the summons, addressed to the Victorian Legal Services Commissioner and to the Chief Commissioner of the Police. The subpoenas could not be issued under Ord 42A of the Supreme Court General Civil Procedure Act 2015 because the plaintiffs are not represented. Under R 42.03(6), the court may order the date to be specified in the subpoena. I have decided to grant leave to the plaintiffs to file and serve a subpoena addressed to Victorian Legal Services Commissioner, substantially in the form of that provided to the court. The Victorian Legal Services Commissioner is associated with the first defendant, the Victorian Legal Services Board. I have not heard from the Victorian Legal Services Commissioner on this issue, and this leave has been granted without prejudice to the addressee's right to apply for an order, setting aside the subpoena in whole or in part. I am satisfied, however, that there is no legitimate forensic purpose for the issue of the subpoena addressed to the Chief Commissioner of Police in the wide form in which it is expressed, and that its issue would be an abuse of process. The issues that arise in this proceeding concern the conduct of the Victorian Legal Services Board. The proposed subpoena seeks extensive documentation relating to interactions between police and an ex-employee of the plaintiffs or one of them, Ms. Delara Anaz. The interaction between the police and Ms. Anaz does not arise as an issue in this proceeding, which is concerned with the conduct of the Victorian Legal Services Board. Further, I am satisfied that many of the categories of documents sought are so extensive that the subpoena may properly be described as oppressive. In circumstances where I have formed the view that the proposed subpoena would be an abusive process, I am also satisfied that the court has power, in the exercise of its inherent jurisdiction, not to allow the subpoena to be issued. All right, so that's the ruling on the recusal application and the subpoenas.
Would the board permit us an adjournment so we can appeal this decision?
I have to make orders before you can appeal. So let's just finish with this mention. Mr. Cooksall, the short answer is I will do something reasonably necessary to allow you to put an appeal process in place if that is what you wish to do.
Yes.
All right. Now the defendants have sought leave to amend their summons in accordance with a draft amended summons dated the 18th of November 2022 with an additional paragraph in the email sent 2024. That seems to me to be a bookkeep, a clarification type amendment rather than.
Which proceeding are we in, Your Honor?
We are in the same proceeding, are we not, Mr. McAuliffe?
That is so, Your Honor, filed in relation to 04028 in which we are still in. Leave is sought to amend that summons.
Mr. Cooksall, do you oppose that?
Absolutely.
Why?
Because the summons is brought on a completely different basis.
Why do you say that? What is the difference? How are you prejudiced by the amendment?
Okay, I am just going to bring up the document, Your Honor, if I could be given a minute to do that.
Okay, I'm just looking for it right now. I was looking at it this morning.
Sorry, was it sent this morning, Your Honor?
No, I am sure I saw it. Mr. McAuliffe, I am not going mad. It was in this proceeding, was it not?
Yes, that is so, Your Honor, it is in this proceeding 04028. The email that was sent I have seen a copy of is dated the 27th of March 2024 which circulated again that proposed amended summons.
Okay, yes, Your Honor, I have the copy of it now.
Yes, Here is the proposed amended, yes.
And of course, as Your Honor will see on the date of the proposed amended summons, which dates back to the 18th of November 2022, is circulated initially some years ago.
Ori, Your Honor, is this the summons where the amendment made this Rule 23.41 instead of Rule 23.42?
Well, yes, the document I am looking at first of all crosses out paragraph 2, which is to do with conditional appearances. So that is relevant. So then it is clarifying that its application is in relation to your further amended summons, not your original summons. And it is saying that the order is brought under 23.02, alternatively 23.01.
Your Honor, it's basically seeking new grounds for the issue of the summons where the previous rounds, so Your Honor, 23.4.
Mr. Cooksall, have you got a copy of the amended summons in front of you?
Yes, in front of me. I am looking at it as we speak. And it is.
Okay, in its unamended form, it ruled in paragraph 1, it referred to 23.01.
That's right.
And in paragraph 3 it referred to Rule 23.02.
I don't have that. What I have, Your Honor, is paragraph, the summons I have.
Have you got the proposed amended summons which is marked?
Yes, okay, I see what Your Honor is saying.
It's just tidying things up, isn't it? This summons?
No, Your Honor, because the manner in which the summons was brought fundamentally was on reliance of Rule 23.411.
Alternatively 23.023. All right.
And what this, Your Honor, it prevents us or precludes us from raising effectively allegations of abuse of process against the LSB when the appeal that we have raised against it was on the grounds that they had primarily relied on 23.01 and Judicial Registrar Keith had permitted that without notice. If the affairs of this proceeding have been conducted on the basis that they were basically relying on a provision that said we have brought a scandalous application to the court and nothing else needs to be said and it must be dismissed. On its face, what they are now seeking to do is rely on the different provision primarily which will permit him to file evidence and so on and so forth. Now,
all right, Mr. Cooksall, I am against you. I take the view that given that the summons always relied on 23.02 and 23.01 in the alternatives,
then why do we need to amend it, Your Honor?
The amendments sought by this summons are mechanistic and do not add in any material way, or do not prejudice the defendants in any material way. Accordingly, I am going to give the defendants leave to file and serve an amended summons substantially in the form of the draft amended summons dated the 18th of November 2022.
I apologize to interrupt Your Honor, as Your Honor is giving the ruling. But if I might just be able to assist, as was also indicated in the email, and this is the email the 27th of March at 9:37 a.m., and this might be what Mr. Cooksall is also referring to, is of course correct to say that Rule 23.01 has always been referred to but as is outlined.
You're bringing in S63 of the Civil Procedure Act.
That is so, and the additional words at the end summarily dismissed, so it is
fundamentally different.
The proposed amended summons is at the 22nd of November, that was never dealt with, so to speak, so it was only just that original summons, but now leave is also being sought to amend the proposed amended summons in the sense that it is not just pertaining.
I appreciate that, and I had that in mind with what I said. I am of the view that it has always been apparent that the defendants are challenging the legitimacy of this action and that the amendments made in the summons I do not consider them to be prejudicing the defendants. So I am going to give the defendants leave to file and serve an amended summons.
Your Honor, we seek a stay of the order.
All right, we will deal with this in a moment. Let me just make the order that the defendants have leave to file and serve an amended summons substantially in the form of the draft amended summons dated the 18th of November 2022 and attached to the submissions filed the 18th of November 2022 with the additional paragraph set out in the defendant's solicitor's email dated the 27th of March 2024 circulated to the court and the parties. Then there is the question of the affidavit of Mr. Anstey. Any issue with that, Mr. Cooksall?
Your Honor, we want.
Will you come to the end?
I have no faith in the court deciding these matters fairly, and I think.
All right.
We simply seek a brief adjournment so we can raise these matters on appeal.
Okay, I'm going to deal with the orders in this matter today, Mr. Cooksall, so you've got something. And if want to appeal, you can appeal. How long do you need to file the affidavit of Mr. Anstey, Mr. McAuliffe?
Your Honor, we haven't been heard about that. We said that we wanted have.
Mr. McAuliffe, how long do you need?
7 days, Your Honor, until close of business next Friday.
So that's what date is that? The 25th?
The 24th of May, Your Honor.
I offered you an opportunity to say why you're prejudiced by allowing him leave to file and serve that affidavit by the 24th of May, Mr. Cooksall. Is there any prejudice you suffer?
Your Honor, they're fundamentally changing the basis on which the summons is brought.
I've moved on from the summons. I'm talking about the affidavit.
Yeah, but it raises the same issue that the affidavit. It's prejudice to us because up until now the orders that the court had made on the 7th of September and the 23rd of August 2023 were on a different basis. There was no anticipation of filing of evidentiary documents at that stage. The subpoena was sought to be, in fact. We had specifically raised this argument to Your Honor that,
Mr. Kuxel, I've got to go in 5 minutes, so.
Your Honor, to be more specific, they're changing the way in which the case is being heard and there needs to be. The whole reason why Your Honor had made those orders was because their case was so efficient, there was no evidentiary documents and so on, so it was convenient and efficient for their matter to be listed, and that was purely the reason why it was listened. Now,
Mr. Kuxel, have you even looked at the affidavit for Mr. Anstey are doing?
But Your Honor,
tell me if you've read the memorandum from the defendant identifying. Remember, I ordered the parties to put in memorandums saying what orders they wanted. The defendants put something in and you didn't. Have you looked at paragraph 4 of the defendant's memorandum?
I have not.
Okay, the proposed affidavit, so you're opposing this application without having looked at what the affidavit's about.
I'm opposing it on the basis that the court had listed the hearing of their summons because it was not time-consuming at all. And the fact that introduction of the evidentiary documents by itself.
All right.
Consideration of that merit.
I'm going to give the defendants leave to file and serve a supplementary affidavit of Mr. Ansell on or before the 24th of May 2024. And you'll see when you look at it, Mr. Ansey, that it's just producing some of the missed emails documentation. Mr. Ansell's affidavit is 2 pages in length, and there's a bundle of exhibits of about 30 pages. Which is a letter from the Victorian Legal Services Board, the People Shop Pty Limited, in relation to his appointment, some interim complaints and audit reports that he prepared, a letter from the Victorian Legal Services Board to People Shop Pty Limited detailing the proposed terms of management direction system, and a management direction system direction dated the 22nd of May 2022. I can't see that the production of those documents prejudices you. So we then work out about.
Your Honor, we have to file material that.
Mr. Kuxel, those directions.
We filed summons.
Mr. Kuxel, just give me a moment. I'm thinking of making those orders. Are you saying that you want to, before anything further happens, you want the opportunity to commence an appeal against these orders?
Absolutely.
All right. So what I'll do then is I will make no further orders in relation to this matter, and I'll list it for mention in 3 weeks' time. Or how long will it take you to initiate?
Sorry, Your Honor, so the orders that Your Honor has foreshadowed, they will not be made at the moment. Is that what Your Honor is saying?
I'm going to make them. But I'm not going to make any further orders.
Your Honor, that is prejudicial to us. What Your Honor is saying that Your Honor will not make any orders that we can benefit from, but.
No, you understand, Mr. Kuxel, I'm giving you the order you can file the subpoena. You can issue the subpoena on the board. And what I'm going to say is I won't make any more orders, to give you the opportunity to the Court of Appeal and initiate an appeal against what I've done today.
Okay, we need 6 weeks, Your Honor.
6 weeks. Is there any reason why I shouldn't list it for mention in 6 weeks? Mr. McAuliffe?
Nothing to say on that proposal, Your Honor.
So I will list it for mention then on a date not before. Let me just bring my diary up.
And the return of the subpoena, Your Honor, when would that be?
Well, what's today? We might do it on the same day. I'm away on the 28th, it's going to be the 5 weeks. It's going to have to be the 21st of June, otherwise it has to go off until the middle of July.
Middle of July is more preferable, Your Honor. We have hearings in between.
All right, I'll make it the 12th of July. It might be, though, that on that date, depending on what happens, I set the issues down for hearing quite promptly after that. So the date on the subpoena, the date that I'll list on the production of documents for the subpoena will be the 12th of July, as will be the date for the next mention.
Okay, but, Your Honor.
And Mr. Kuxel, I'm going to order that you serve with the subpoena a copy of the order that I authenticate.
Okay, but, Your Honor, so the court, if there is an objection to the subpoena, is Your Honor proposing to hear it on the 12th of July?
Well, what happens about that?
What we want to know is if the court is potentially scheduling a full day, in the sense that we have make ourselves available for a full day, or whether we'll just be a brief mention.
I don't know at this stage. It depends what attitude. The Victorian Legal Services Board might not want to set it aside. They might just produce the documents. If you want, it might be safer to set it down on the 11th of July. On the 12th of July I could not give it a full day.
Okay.
In light of my diary.
That's fine, Your Honor.
I'll set it down on Thursday the 11th of July. I have the dates the 11th of July instead, so if need be, I can spend a bit more time on it.
Your Honor, if I might just interrupt, and of course subject to the plaintiff's position, is Your Honor available? Is it possible to have the matter listed on the 10th of July?
It's okay by me. Mr. Cooksall, do you have an issue about that?
I'm just checking with Ms. Zhu about my schedule.
It's okay.
We are agreeable with that.
All right, I'll make those dates. Thank you all for being cooperative on that.
Thank you.
I'll make it the 10th of July. And presumably, Mr. Cooksall, there will be some communication by the Victorian Legal Services Board about whether it is going to apply to set aside the subpoena or whether it's going to comply with it. And we should know that in time to work out what's going to happen on the 10th of July.
Yep.
All right, I will try to authenticate this order and get it out. If I don't get it out.
So, Your Honor, may I clarify if the court will allow us to issue a subpoena to the Chief Commissioner only for item 10?
Well, you'll have to deal with that again.
No, if the court allows it, then we.
Mr. Cooksall, no, Mr. Cooksall. I've got to go somewhere else, at the moment. If you want to produce a different proposed subpoena.
Just item 10, Your Honor.
Well, I've lost what item 10 is now.
It's the item that Mr. Hallberg communicated to Mr. Oni was about the events of the raid on the firm's office. The 22nd of August 2022.
I'll tell you what I'm going to do. So without bringing the subpoena up again, are you saying it's his one identifiable small document?
Well, I don't know how big or small it is. But one document.
Tell me what it is again.
It's the notes made by one of the police officers that accompanied the LSB on the 22nd of August 2022 to seize the firm's property and its court files.
So it's the notes made by one police officer.
Of the two police officers that accompanied the police about the event of the day.
The notes made on that day. By those.
About the day's events. The notes made about the day's events.
On that day, or the notes ever comment ever anything else?
I don't know, Your Honor, but it's about that day. It's about the day. Only about the day that.
Mr. Cooksall, look, if you want to formulate a different type of subpoena.
I contend.
Mr. Cooksall, listen to me. I just can't deal with it now. If you want to prepare another form of subpoena that is substantially more limited in respect of the police, do that and circulate and I'll have a look at it.
But Your Honor, they don't have a say, it's an agreed fact. So it's just.
I'm telling you, Mr. Cooksall, I'll tell you what I've said. You've produced a document, I've said that document, you're not allowed to issue that document. If there's another form that you want to issue, prepare it and circulate it.
Okay.
Now, in terms of the other matter that's listed for mention today, we're going to have to adjourn to another time. I would like to deal with that on Monday. Is there any reason why people can't come on Monday? Perhaps we should call matter 3994.